Yeah, I will make a response as far as the Uganda Human Rights Commission is concerned in terms of the acute strain that seems to be internally riven by serious misconduct allegations and even leadership infighting, and extremely constrained by the chronic under resourcing in terms of heavy case backlog and even a deteriorating civic and even electoral rights environment. I know that the Human Rights Commission gets its mandate by virtue of Article 51 of the Constitution. That remains intact, but its institutional credibility and effectiveness are actually being eroded by the convergence of governance failures within the Commission and the broader human rights context, which help it to function in that respect. Now, in terms of the ongoing saga, particularly in terms of what is happening at the Commission, we could address this in the context of governance, but also in terms of the leadership crisis that has befallen the Uganda Human Rights Commission. For starters, we could argue and understand that the Commissioner's petition, for example, that has been alleging misconduct and even maladministration. There are three commissioners in the names of Simon Nsubuga, Colonel retired, Stephen Basaliza, and Jacqueline Atuhaire, who have actually petitioned the president and the Inspector General of Government, who are alleging there is a financial misconduct, there's an abuse of office, and also an aspect of maladministration within the Uganda Human Rights Commission. Now, the allegations reportedly cover the things to do with the NSSF contribution, salary enhancement, office funds, procurement, recruitment, and promotions. And the Commission has actually publicly dismissed these allegations as false and defamatory. But the very existence of a signed high-level internal petition signals deep institutional fracture and invites external scrutiny that distracts from the core human rights work in terms of what takes place at the Commission. Number two, in terms of the chairperson's public critique of appointments and even internal fighting, that is also something maybe we need to be critical about. The chairperson, Mariam Wangadia, has publicly accused, for example, the president of undermining the commission by appointing broke and sickly political failures, framing the internal discord as partly a product of politicized appointment. She is also reported to be approaching the end of her term with a section of commissioners who have actually probably ganged against her, derailing the commission's agenda. And this public airing of grievances, while perhaps politically understandable, further damages the perception of the Uganda Human Rights Commission as an independent, cohesive, constitutional body. And that is something also important to understand. And then number three, we could also look at it in the context of parliamentary criticism over priorities and compensational awards. You will recall that in April 2025, Parliament's Legal and Parliamentary Affairs Committee sharply criticized the Uganda Human Rights Commission for misplaced priorities, notably a proposal to procure Fonte presidential portraits and for neglecting detention centers in the central region amid allegations of abduction and torture. And also, MPs also condemned the compensation awards as ridiculous because they were as low as 5 to 7 million for torture and related violations, arguing that these frivolities harm the unentrenched impunity instead. And the chairperson acknowledged operational challenges and noted that in 2024-2025, the Commission registered about 1,606 complaints, of which only 95 met admissibility standards and just 16 were actually resolved, figures that underscore both high demand and low throughput out. Now, if you argue in terms of the operational performance, in terms of the caseload, for example, in terms of the backlog, for example, and whether or not there are any substantive remedies at the Commission, we could be quick to understand that number one, the complaints in terms of profile and case flow, Uganda Human Rights Commission in terms of 2025 annual report, which was filed on the 28th, the so-called the 28th report, records 1,747 complaints. And in 2025, with 324 registered as raising alleged human rights violations. The largest share of complaints was against the Uganda Police Force, about 181, followed by private individuals, about 85, and the UPDF, about 37. Ministries and agents, about 16, and Uganda prisons, about 9. The most common alleged violations were deprivation of personal liberty, about 133, freedom from torture, about 117, and denial of child maintenance, about 74. All this is important to note. Number two, in terms of investigations, in terms of mediation, in terms of referrals, and in terms of tribunal disposition, for example, you'll be quick to understand that in 2025, the Commission investigated about 1,011 complaints, mediated about 81, and referred about 3,181 complaints to other institutions. So the Uganda Human Rights Commission Tribunal had about 252 matters and disposed about 131, awarding a total about 885 million in compensation for violations involving the right to life, personal liberty, and freedom from torture. While these numbers show activity, they also reveal a bottleneck. Only a fraction of investigated cases reach the final disposition in a given year. That perhaps is also food for thought. Now also, if you look at the backlog and resource constraints, even before 2025 figures, the Commission was already struggling with a mounting backlog of unresolved complaints, some dating way back as far as 2016, including election-related matters. And in 2024 alone, 691 complaints were actually registered, with about 411 against the police and about 144 against individuals and 96 against the UPDF. The Commission was also investigating about 90 torture-related cases from 2024, with another 57 carried over from 2023. So officials attribute delay to operational and even administrative challenges, including inadequate resources and a manual complaints management system that hampers tracking and even follow-up. So these, again, are serious issues in terms of the Human Rights Commission. Now, if you argue in terms of the compensation, in terms of the adequacy and payment delays, beyond the quantum concerns raised by the MPs, the Commission itself flags delayed payments of compensation to victims as a systematic challenge. When remedies are both modest and even delayed, the deterrent effect on violators is actually weakened, and the public confidence in the Commission predictive role diminishes in that context. So all these are serious concerns for the nation in terms of the works at the Human Rights Commission. Now, also important to note is that the human rights context in which the Uganda Human Rights Commission must operate becomes fundamental in the context of the discussion that we're having. How? The electoral tensions and the aspect of what they call the civil liberties. You will be quick to understand that the 2025 report highlights a turbulent electoral period with election-related tensions, media crackdowns, and hundreds of arrests during the heated poll season. Yes? So as of 2026, general elections approach, for example, in terms of what happened, officials warned that there are new cases that are likely to rise and add on the existing backlog within such an environment. And the Commission's capacity to promptly investigate deprivation of liberty and tortures completely became very critical, and therefore caused a very important aspect in terms of preventing the escalation and the protection of civic space. And that is what we're seeing even deep into 2026. Now, if you look at the broader rights deterioration and the civic space in terms of the independent monitor's report that Uganda Human Rights Commission's record, it continues to deteriorate under long-standing executive dominancy with shrinking civic space, politically motivated charges, for example, against certain NGOs, and the use of colonial-era offenses against protesters, for example, and the Constitutional Court upholding of key provisions of the talk about the anti-homosexuality bill that further entrenched this aspect of discrimination and even the risk of violence against LGBT persons. These trends expanded the Commission's potential caseload, while simultaneously testing its independence and the willingness to confront powerful state actors in this context of what's happening in that regard. So you will realize that the issues that are affecting the Commission are bigger than what meets the eye in terms of that analysis, but also in terms of an assessment, how grounded is Uganda Human Rights Commission in terms of performance. Perhaps that becomes the bigger question. And on paper, one can argue that the Uganda Human Rights Commission continues to perform core functions, receiving complaints, yes, conducting investigations, yes, running a tribunal, yes, inspecting places of detention, yes, and even publishing annual reports. Yes, and we could look at, for example, if you look at in 2024, 2025, it reported that inspecting of about 303 detention facilities, which included things like 72 prisons and about 230 police stations. And then in 2025, it awarded about 885 million in compensations across 135 disposed tribunal matters. Yes, we see it on paper, as I said, but feeling is another question. However, these structural weaknesses now dominate its performance profile, and that is where perhaps the bigger question should be laid in how to address this bigger problem. In terms of governance instability, the internal rift, in terms of the commissioner's petition, in terms of the public accusations against the president's appointment choices, and claims of factionism, that this basically undermines the commission's institutional coherence and perceived independence. And that is something, again, that is probably deep at the root of the commission. Now, through deficit, one could argue that there are substantive high complaint volumes, low admissibility, for example, in terms of resolution rates, and even a multi-layer backlogs in some cases pending way back in terms of 2016. So these indicate that the commission cannot currently match demand with timely, effective remedies. And this is something, again, maybe that the commission has to think about in terms of that. And then in terms of how do you remedy this weakness, the modest compensation awards could be coupled with payment delays, but that's a big problem because of the finances. In terms of reduction to the normative force of the tribunal's decision and high-risk signals, in terms of the tolerance of serious violations, it also becomes another question of debate. So in this light, the Uganda Human Rights Commission is formally active, yes, but functionally constrained. It is doing the work it's mandated to do, but not at a scale or even speed or authoritative weight required to meaningfully check abuses in the current political climate. And so if we can address those, then I think we can have a good discussion in terms of way forward. But also what would extremely would be required in terms of the reform. The reform, what would you look at in terms of reform, in terms if you want to look at the reform of the Human Rights Commission? If the aim, for example, is to restore credibility and impact, reforms must address those internal governance and even external operating conditions to the root. Because when we deal with the root, then we shall do away with the symptoms that are manifest even as we speak today. So we could talk about things like resolving the governance, crisis credibly. We could argue in terms of an independent, a time-bound inquiry into the commissioner's allegations with clear safeguards against retaliatory action, for example. This becomes necessary to either vindicate or even sanction misconduct and to reestablish internal discipline within the commission. That becomes extremely, extremely important. And then the aspect of depoliticize appointments and strengthen tenure security without insulating from partisan patronage. Any chairperson will actually struggle to command internal loyalty and even external respect if that is not addressed. We could also talk about things to do with modernized case management and even invest in terms of capacity. Yeah, the documented reliance on manual systems and inadequate resources must actually be addressed through digitalization, for example, case tracking tools, for example, and adequate budgetary reforms to reduce backlog and even improve the follow-up that is actually required. And then we could also think about things to do with the recalibrating remedies. Yeah, we can argue that Parliament and the Commission should actually revisit compensation guidelines and ensure awards that reflect the gravity of these violations. Yes, especially torture and even unlawful detention, and ensure prompt payment to restore faith within the tribunal. That becomes very, very important. And then you could also talk about strategic focus in terms of high risk violations, for example, with, for example, elections imminent, left, right, and center within the country, the police and UPDF complaints become dominant, and the commission should actually prioritize deprivation of liberty, torture, and even politically sensitive cases, including unannounced detention inspections in hotspot regions, not just peripheral areas. That becomes extremely important as a way forward in terms of addressing some of the biggest challenges that we want to talk about. So that, my friend, becomes the bigger question in terms of the works of Uganda Human Rights Commission as we may know it today. So that would be my humble submission. I thank you.